Going on the record in the matter of the state of Michigan versus Michelle Vasi, 24625. Counsel, your appearance, please.
Good morning, Your Honor. Sanford Shulman, P43230, appearing on behalf of Michelle Vasi, who is appearing by way of video conferencing for the Wayne County Jail.
All right, thank you. And ma'am, your name for the record, please.
Michelle Vasi.
Okay, thank you. All right, and counsel, today is the date scheduled for the probable cause conference, and you had an opportunity to speak to your client and the prosecuting attorney, correct?
I have, Your Honor, yes.
Okay, and so what is happening?
Ms. Vasi is prepared to waive her statutory right to a preliminary exam. I am in receipt of the discovery. I received it last night, but I reviewed some materials with her yesterday, and she understands that she could have a preliminary exam. The burden would be on the people to prove that there was a crime and that she committed that crime by probable cause. And she knows that she'll be bound over. She asked me to, if the court accepts that waiver, I would like to address bond.
Okay. And so, ma'am, you heard everything that your attorney just stated, correct?
Yes.
Okay. And so you do understand that you do have the right to have a preliminary examination where it must be shown the crime was committed and probable cause exists to charge you with that crime.
Yes.
You also understand that by waiving your right to your preliminary examination, you will be bound over to circuit court for further proceedings on the charges in the complaint and warrant, correct?
Yes.
And you received notice of the charges in the complaint and warrant, is that correct?
Yes.
All right, has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
No.
All right. Examination having been waived, defendant is bound over to circuit court for further proceedings. You are to appear in circuit court on May 30th at 9 o'clock in the morning on the charges in the complaint and warrant. Counsel, any objection to the court stating or writing on your signature lines for both you and your client via Zoom? Is that acceptable?
No, please do. Yes, please do. Thank you.
Okay, thank you. All right, so then counsel, bond is currently $10,000, 10%, GPS tether, no driving. So the event bond is posted, GPS tether, no driving, submit 30 job applications per week. And counsel, you would like to address bond?
Yes, Your Honor. We're asking the court to amend it to a personal bond with the tether. She's a lifetime resident of the city of Detroit. I know there's some failure to appear, but she has 2 daughters. She's no felonies, and she's 40 years old. I met with her. She communicated well with me. She can't post the 10,000, 10%. It's unfortunate. It's a relatively low bond, but with a tether, I think it could appease the court's concern of any flight risk or threat to the community, and I don't think she's either.
Okay, thank you. And so, counsel, the court, in making its original bond determination on May 17th, the court did review the criminal history, which she has some felony matters from 2023, quite a few felony matters from 2023. Some that include drugs, and all of those were either dismissed or not prosecuted. There's a matter in Lincoln Park, a felony dangerous drugs and stolen property. There's a warrant that's been requested on that matter. There's a felony traffic offense out of Detroit that was released, no prosecution. And now we're here, weapons offense, felony stolen property, felony traffic offense, misdemeanor. In addition, your client has warrants dating all the way back to 2016 out of the 36th District Court, 36th District Court, 36th District Court. Then we have another 36th District Court, 1, 2 more of those, 3, 4, 5. Then 6, 7. Then we have one out of 40th District Court. 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22 warrants so far of the 36th District Court alone. Then there's a warrant, the matter that she has, the felony matter I mentioned, that warrant's pending out of Lincoln Park. So your client not only is a threat to the community with her charges and behavior that's alleged, is your client fails to appear for court. And so for those reasons, the court is not going to amend the bond. The court's going to maintain the bond so we can make sure this matter is being taken care of. And perhaps she can handle some of the other matters that she has failed to appear on in the interim while she's in custody.
Thank you, Your Honor. May the court consider a DSU report or DSU referral, I should say?
I will make that referral. So the
Okay.
request to reduce bond is denied. Bond and conditions are continued. Refer to DSU. Okay, thank you. Have a good day.
Yeah, great. Thanks, Judge.
Thank you. And we're.
Okay. Go!
You hand me my screen box. Now go free. Rah.
Okay, and so we will go on the record in the matter of the state of Michigan versus Kennedy Sykes, 2427, and appearance, counsel.
Good morning, Your Honor. Omar Sharma on behalf of the people, PH 6332.
Thank you.
Good morning, Your Honor. May it please support Douglas Mons, People 0916 on behalf of Mr. Sykes, who's seated to my right. Sir, could you stand up and state your name for the record, please?
Kennedy Sykes.
All right, thank you, and good morning. And so today is the date scheduled for the preliminary examination, and counsel, the examination is going to hold, correct?
That is correct. The people are ready to proceed at this time.
Okay, and defense, you're ready to proceed?
We're ready, Your Honor.
All right, any preliminary matters that we need to address?
We're only requesting a mutual sequestration order of any non-potential witnesses in this case, with an exception to the OIC, Detective Vasi, who is present in court.
Okay, any response?
Yes, no objection. Mr. Sykes' mother is in the court. I'm going to ask her to step out, just in case, because I understand that if she may even testify at trial, that she should not be a part
Correct.
of the examination.
All right, thank you. Okay, and ma'am, if you can have us step out, a seat outside in the lobby. Very nice. Okay. All right, and anything else?
Nothing further.
Okay, it's my understanding that there's a stipulated exhibit.
That is correct, Judge. I was going to introduce it with my second witness,
Okay.
or we can examine. I can introduce.
Well, since it's stipulated, we can just indicate that now. Is that
Yes, Your Honor. My understanding is just the lab report.
correct?
That is correct.
Okay, so,
The people move to admit pursuant to MCL 766.11B, Judge, which is an MSP lab report which shows nature of offense, controlled substance violation of Controlled Substance Act, suspects Tamiko Austin Lee and Sykes Kennedy Earl. Judge, the evidence received was container number one adhesive sealed plastic evidence bag, agency number 1243, containing 1 twisted clear bag holding 1 rectangular white tablet. Container number 2 is 1 adhesive sealed plastic bag, agency item 1244, containing 1 clear plastic bag holding a number of round blue tablets, Judge. And the substance that was indicated, Judge, was fentanyl. The
Okay.
people move to publish at this time.
okay, and that's People's Exhibit.
1.
Okay, all right, thank you. And counsel, you stated that you're stipulating to that for exam
Yes,
purposes.
for exam purposes only. Your
Okay,
Honor.
thank you.
HRISTOPHER, and last Shrine, SCHRA, 2 M's and 2 M's.
Thank you, and counsel, you may proceed.
Thank you, Judge. Can you please restate your name for the record, sir?
Christopher Shrine.
And how are you currently employed?
I'm a patrol officer for Riverview Police Department,
And how long have you been a police officer with the Riverview Police Department?
approximately 3 years,
Okay, and are you assigned to any particular unit in that department?
just FTO.
Okay, and were you working in that capacity as an officer on 11/23/2023?
Yes, I was.
And did your duties take you to the location of 1-8?
Yes, I did.
And were you dispatched to this location at this time, or were you on routine patrol?
We were dispatched, it was a suspicious vehicle.
Objection, Your Honor.
Okay, just 1 moment. Okay, yes, counsel, your objection.
My objection is to hearsay. I'd like to hear from an officer while he was there, other than what the dispatch said.
I'm sorry, you what?
The dispatch, hearsay.
Okay, and your response, counsel?
Judge, it's not being offered for the truth of the matter asserted, first of all, because it's just offered to show what he did based on his response from the dispatch. Also goes to the effect on the listener as well.
The court's going to overrule the objection, a little bit of leeway to see what the anticipated testimony is. And then counsel, if you want to renew your objection, you certainly may.
Thank you, Your Honor.
You're welcome.
Excellent, thank you. So you responded to that location?
Correct.
Okay, and what anything did you observe when you responded?
The vehicle was on with its headlights on.
Okay, so where specifically was this vehicle?
It was parked in front of a group home at 1878 Seminary Street.
Okay, and were you with any other individual, any other police officer?
Yes, Sergeant Phil and Officer Miller.
Okay, were you working in conjunction with them at the time?
Yes,
Okay, were you alone driving your patrol car?
yes.
So who responded to that scene first?
I believe it was Officer Miller.
Okay, and when you got to the scene, what if anything did you observe?
We observed a black 2003 Ford Explorer parked. We observed two individuals, one in the driver's seat and one in the passenger seat. White male was in the driver's seat, black male was in the passenger seat.
Okay, and specifically, did you approach the driver's side or the passenger side of that?
I approached the passenger side of the vehicle.
Okay, and what if anything did you observe when you got to the passenger side?
Both the driver and passenger were slumped over the wheels, sleeping, and we had to knock at the window to get them up and kind of yell, use loud verbal words.
Okay, and did you specifically make commands to them?
Yes, I was saying, hey, knocking at the window, trying to get the passenger's attention.
Okay, and were they responsive to that?
The passenger, after a few attempts, the passenger did wake up.
Okay, and did you describe their demeanor?
He appeared disoriented. He was slurring his words when speaking with me. And I had him roll down the window, which he cooperated. And I asked him if he knew where he was, and he said he believed he was in Plymouth,
Okay, and in fact, what city was he?
Riverview.
Okay, and you see that individual that you made contact with in the passenger seat in court?
Yes, I do.
Can you please say where he is seated in an article of clothing that is wearing?
I see it to my left, and he's wearing a blue button-up.
Okay, can you describe any other features?
He's a black male.
You're gonna let the record reflect the identification of the defendant in this case?
All right, anything for the record, counsel?
No, no.
All right, the court will note that Mr. Sykes is the individual wearing a blue shirt, a blue button-up shirt. Yours is not blue.
He's not.
Might be a shade of something, but gray maybe, but not blue. So the court will, the record will reflect the defendant was identified.
Thank you, Judge. Now, was there an officer that responded to the driver of that vehicle?
Yes, Officer Miller.
Okay, and following, you indicated earlier that he rolled down the window at this point, correct?
Correct.
Okay, and what if anything did you do at that point?
Officer Miller was speaking to the driver. Officer Miller, I believe, opened up the door. He observed what he believed was.
Objection, Your Honor, as to what the other officer observed. I think this officer can testify as to what he observed.
Okay, your response, counsel?
Judge, I'll rephrase.
Okay, the
So-
objection is sustained.
What if anything, did you observe anything specifically to you in connection with the Officer Miller?
When I walked over to the driver's side when I walked over to the driver's side of the vehicle, I observed Officer Miller pull out a sandwich bag of drugs. He also informed me that he found.
Objection, Your Honor.
Don't tell me what he said.
Okay, hold on, counsel, hold on. There's, gotta make sure the record's clear as it can be. There's an objection.
Objection is the hearsay as to what the officer informed him of.
Okay,
And
Mr.
Judge,
Shadra.
if I may, Judge, officers that are working in conjunction together, the communications between both of the parties is not hearsay. It's showing how he responded to that communication based on his work or based on the way that they've been communicating or their collaboration together pertaining to the case. But I can rephrase. He indicated that he observed a bag
Okay.
of suspected narcotics.
Okay, just a moment, and counsel, your response to that
My
argument?
response is, Mr. Sykes is charged with a crime of allegedly having drugs and narcotics. This officer is going to testify that the other officer told him that there were drugs and narcotics present, and that's to the issue in question. It's not just banter between officers. That would clearly be hearsay.
Okay, so the court's going to sustain the objection. You can rephrase the question.
Okay, you indicated you observed the officer pull something out of the driver's pocket.
Correct.
What, if anything, did you observe?
His bag full of pills.
Okay. Now, at that point, did you guys ask the drivers out of the vehicle, or did you ask the driver out of the vehicle?
Officer Miller did. I asked the passenger to step out of the vehicle.
Okay, and did he cooperate?
Yes, he did.
Okay, and what, if anything, did you do when you asked him out of that vehicle?
He stepped out. I detained him. He was placing cuffs. He was placing the rear of my patrol vehicle.
And then did you return back to the vehicle?
Yes, I did.
And what, if anything, did you do when you returned back to that vehicle?
I found one blue pill on the passenger seat, also with blue pill residue on the passenger seat with shards of a pill. Also, we found $2 bills that were rolled up with residue, and we also found a debit card that had pill residue on it.
Okay, now, at that point, were you inventorying the vehicle?
Yes,
And was the driver outside of the vehicle already?
yes,
And was he placed in the patrol car?
yes.
So what, if anything, did you do with that pill though?
We placed it in an evidence bag with other drug paraphernalia that we observed.
Okay, now, that pill specifically, can you describe it?
Yes, it was a blue pill. I believe it had Leonard M and 30. It was later identified on drugs.com as oxycodone.
Okay, now the pills.
Objection, Your Honor. I think it being identified on drugs.com is not contained in the lab report, and I think it's objectionable as hearsay. As to what drugs.com is saying about what was allegedly found.
Judge, as part of his investigatory inquiry, he's making an inquiry into what the actual substance or what this pill is going to be identified as. Well,
Okay, let me ask one question. Do you utilize drugs.com in your normal course of business for investigation purposes when it, regarding narcotics?
Yes, I do.
Okay, the court's going to overrule the objection, and the court is aware and will take judicial notice that drugs.com is commonly used to assist officers in identifying substances. Counsel, I'm not ruling that that identification is the basis for anything at this point. That appears to be part of the investigation at this point. Okay?
Thank you, Your Honor.
All right, so the objection's overruled. You
Thank you.
may continue.
now, you took that pill specifically on the seat itself. Where was it located?
It was on top of the seat, probably approximately in the middle of the passenger seat, I believe.
So that specific pill, where did you retrieved it, correct?
Yes,
And you placed it into evidence?
yes.
Okay, and the other pills that you indicated were located, were those pills placed in the same area?
No, I believe Officer Miller took the bag that contained all those bills, the 674s. Oxy. I believe he transported those, and I transported the drug paraphernalia and the one pill.
Okay, did you transport the defendant back to the PD?
Yes, I did.
I'm sorry, did you say 674 pills?
Correct. That's what was counted when we arrived back to the station in the bag that was found on the driver.
There was a vehicle towed?
Yes, it was. It was inventory and towed.
Your Honor, no further questions for this.
All right, thank you. And
Morning, officer.
counsel, if it's more convenient, you can adjust the podium or microphone, whichever you prefer. You can turn, just watch the court there, please.
Thank you.
You're welcome.
Officer Schramm, am I saying that correctly?
That's correct, Shram.
Schramm. And with regard to the person you identified as Mr. Sykes, you initially indicated that both persons were slumped over the wheel, but that's not possible, right? You meant the driver.
The driver and passenger. Yes, correct.
Well, I'm sorry, counsel, let me clarify. The testimony, because I was writing it down as the officer was testifying, the testimony was that it said they were both slumped over. There wasn't anything that, there wasn't any testimony that said slumped over the wheel.
Okay.
What I didn't hear the word wheel. If you did, okay, but I just want to make sure that we're not mischaracterizing any testimony.
Sure.
So.
Yeah, that's just what I wrote down, Your Honor.
Okay, I just, what I heard was slumped over. Both were slumped over.
Right. And officer, you indicated when you first, well, the vehicle was parked, correct? When you first approached it?
Yes.
And it was parked on, was a residential street or business street?
Residential.
Was it parked legally at the time?
Yes.
And you indicated that there were two people in that vehicle,
Correct.
and both appeared to be sleeping,
They were sleeping.
and the first thing you did was knock on the window, right, of the passenger side. When you after you approached the vehicle.
Correct, yes.
And you did also indicate that the window was rolled down.
It might have been used by a button, but it was, the window was put down.
So was that the first thing that happened after you knocked on the window was rolled down?
It was when he woke up, when I knocked on it, when I actually saw his eyes open and he lifted himself up, then I asked him to roll down the window, which he did, or put down the window.
And was that the first thing that you asked was for him to roll down the window? If you can recall.
I can't recall.
And you did indicate that after you rolled down the window, the passenger at least was cooperative, correct?
Unsure.
Did you say sure or unsure?
Unsure.
You're unsure whether he was cooperative?
Yes, it would be, he was speaking mainly with Officer Miller, so I believe I can't really answer their interaction.
So are you also unsure when you testified earlier that he appeared to be disoriented?
No, because I heard him speak.
Was he responding to you, or was he responding to another officer?
He was responding to another officer.
So
I'm
what-
sorry, did you ask about the driver or the passenger?
I'm asking specifically about the passenger.
Okay,
So we're talking about the passenger, officer, right? Because you approached the vehicle on the passenger side,
Correct.
knocked on the passenger window,
Correct.
and had interaction with the passenger.
Correct.
And you're identifying the passenger as Mr. Sykes.
Correct.
And the passenger also had conversation with another officer other than yourself.
Negative, I'm sorry. I believe you were talking about the driver. I got confused.
Okay, so we're only talking about the passenger. This case is only about Mr. Sykes, okay? And if you are confused by any questions, just asking you to clarify, restate, I'm happy to do so. So when it came to the passenger, Mr. Sykes, was there any sort of sobriety testing done with him?
No,
Did he, to your knowledge, make any sort of admissions, any statements to you?
my knowledge, no.
And other than using drugs.com, was there anything that you did to identify one pill that was found on the passenger seat of the vehicle?
No.
And in terms of, you made some testimony about a number of pills that were found, but none of those pills were found on the person of the passenger, Mr. Sykes, were they?
No.
And you made some other statements concerning a credit card, I believe, a debit card.
Credit card, debit card, yes.
That was not in the name of Mr. Sykes, was it?
No, it was not.
Was there any other evidence that you obtained specifically from the passenger seat of that vehicle?
Not to my knowledge.
any redirect, counsel?
There's nothing further for the people for this one.
Okay, very good, thank you very much. Please don't discuss your testimony with anybody. And do people have any other witnesses?
Yes, Judge, if you would put the glasses in.
Please raise your right hand. You solemnly swear or affirm the testimony about to give this man be the truth, the whole truth, and nothing but the truth.
I do, Your Honor, and I do have a copy of my report. I'll place it.
Very good. Thank you very much. And if you could please state and spell your first and last names, please.
Detective Matthew Lyles, Lyles, Matthews, Matthew, badge number 62.
Thank you. And so, Mr. Mons, any objection to the officer having his report up there? It's just so you know, it's flipped upside down. He's not, it's just there apparently in case he has to refer to it, but it's upside down so he can't read it while he's testifying. Any objection to that?
No objection, as long as it's the same one I have a copy of.
I would presume that it is, but in any event, it is face down, so,
It is a copy of the investigation report.
okay, there we go. Okay,
Thank you.
all right, you may proceed, counsel.
Hey, good morning, sir. Can you please just say your name for the record?
Detective Matthew Lyles.
Okay, and detective, how are you currently employed?
I'm employed through the Riverview Police Department.
Okay, and were you assigned to the case of People v. Austin Lee Tamiko and Kennedy Earl Sykes?
I'm assigned to the Detective Bureau and the case was assigned.
Okay, and as part of your investigation on this case, did it include collecting evidence?
It did.
Okay, and what if any evidence did you collect?
The officers on the road from traffic stop collected numerous pills, 2 different types. Those pills were transported to the Michigan State Police Lab for testing, which is congruent with our policies and procedures.
Okay, now as it pertains to the pills itself, were you able to determine what pills came from either defendant?
It was stipulated in the reports how the pills were collected. And yes, there were multiple pills collected, some taken from one defendant and one taken from Mr. Sykes.
Okay, now as it pertains to the pills that were taken from Mr. Sykes, did they have any markings on them?
Objection, Your Honor, I think the testimony is that there was 1 pill taken from Mr. Sykes. And the prosecution is asking the question as though there were multiple pills. And clarify before the answer is given.
I'm sorry, what is it you want clarified, counsel?
I believe the officer in his testimony has indicated 1 pill, a single pill, was taken from the defendant Sykes. I could be wrong,
Okay,
but that's the answer that I heard
from Detective Lyles.
from Detective Lyles.
Okay.
The question from the prosecutor was multiple pills taken from the defendant. And I think that's a mischaracterization of the evidence that's on the record.
Judge, I'm only asking you, he didn't make an inquiry, he didn't answer the question.
And what was your question, Mr. Shajra?
Judge, I asked the detective from the pill that was taken or pills or the pill that was taken from the defendant in this case,
Okay,
whether or not he identified it.
okay, so I'm going to sustain the objection. Mr. Shajra clarified his question. So, okay, so now you may answer that, Detective.
Yes, the pill that was taken from the passenger side with Mr. Sykes was identified, yes.
How did you identify it?
It was identified through drugs.com, which is a law enforcement resource that we utilize on the regular. It is a regular basis. I've used it 50 to 100 times throughout my career. I've also used it in previous cases, and it has given me results that were indicated equivalent with an MSP report. So it is a reliable resource. And the pill that was in Mr. Sykes' side of the vehicle was identified as oxycodone.
Okay, and was there other markings on the other pills that were collected from the other defendant?
Yes, the other defendant was in possession of roughly 670 pills. And those pills had the same markings as the pills in Mr. Sykes' possession.
Objection, Your Honor, mischaracterization. He's saying that there are pills in Mr. Sykes' possession. And that's not what the evidence indicates, that there were pills, multiple pills in Mr. Sykes' possession.
I misspoke, I meant pill. I apologize.
All right, thank you.
Okay, thank you.
Now, did you take those pills to the MSP?
I did.
And did you take specifically that pill that was located on defendant Sykes?
We did not, because the identifiers marked on the pill based on the color, shape, and markings on the pill were equivalent to the 674 pills that were found in the other bag. So therefore, based on it being, within the same area of the search, And based on the fact that the defendants were together, a reasonable person would believe that the pills would be from the same batch,
Okay,
which is
and
not unusual.
And you provided that to MSP, correct?
We did.
Okay, and are you familiar with MSP's policy?
Yes, and they will only test a certain number of pills per case because of their caseload.
Okay, and those pills that had the same identifiers on it were given to MSP.
They were.
I don't know for the person.
That's a large batch, to be clear.
Thank you, Judge.
I'm sorry, I didn't understand the last part of the answer.
The large batch, the 674 pills, was the batch that was delivered to MSP for testing.
Thank you. And cross-examination, counsel?
The second one was, just so we're clear, only a single pill was taken from the passenger seat of the vehicle, correct?
Correct, but it was consistent with the batch.
And the batch was tested, correct?
Yes,
But the single pill was not tested.
correct, sir.
And drugs.com does not test pills, do they?
No, they utilize the shape, size, and markings on the pills. It's almost like an encyclopedia of narcotics. And what it does is it gives us a roadside idea of what that pill is. And like I said, the markings that are on the pills, I've always had match up to drugs.com as a reliable resource.
And according to this reliable resource, drugs.com, this single pill that was found on the passenger seat of the vehicle where Mr. Sykes was sitting was identified as oxycodone, correct?
Correct.
And oxycodone is not an illegal drug, is it?
It is a controlled substance, yes.
Is it illegal to obtain?
It can be without a proper prescription, or if it's, I'm sorry, you possess it without a proper prescription.
So with a proper prescription, it is not illegal
Correct.
to have that, correct?
Correct.
So you identify this single pill as something that is legal to possess with a prescription.
But it was not in a prescription bottle with a prescription, so therefore, no, it's not legal.
Now, when it comes to Mr. Sykes, was he ever drug tested?
Not to my knowledge.
Was there ever a sobriety test on him? Sobriety test?
I wouldn't be able to testify that I was not there for that.
And you're the officer in charge of the case, correct?
Correct, I'm the lead detective on the case.
And as lead detective, you reviewed the other police reports,
I did.
and to the best of
There
your
was-
knowledge,
there was no mention.
no mention of sobriety tests.
Yes, sir.
Any mention of admissions from Mr. Sykes?
No, sir. Not to my knowledge.
Any statements from Mr. Sykes?
Not to my knowledge.
And of the pills that are mentioned in the lab report, all of those pills were taken from the person of the co-defendant, Mr. Timko, correct?
Correct, but as I stated in my previous testimony, the pills that were located on Mr. Sykes are equivalent to the pills that were off of Mr. Timko, which would lead, in my opinion, a reasonable person to believe that they're from the same batch,
But there's no scientific proof of that fact.
Correct.
And the credit card that was found, or debit card that was found, that actual residue, isn't it true that that belonged to Mr. Timko?
I would have to refer to my report.
That would refresh your recollection.
Yes, sir, you were correct. The credit card did have Mr. Timko's name on it.
And there was no other evidence linking Mr. Sykes to those narcotics, is that correct?
Well, there was the pill that was found on his side, and then his condition that was stated in the report of, he appeared to be slurring his speech and out of it. Those are all, I mean, I've been a police officer for 6.5 years. In my time and experience, I've encountered numerous individuals that are under the influence, and all of the indications in the report are consistent with a person who is under the influence of narcotics.
Now, let me ask you this, Detective. So did you personally speak with Mr. Sykes at the scene?
Well, I wasn't at the scene as I testified before, but based on a previous question to me of reading your reports, that's how I'm aware of this knowledge.
So, and Officer Schramm is the only other officer to testify in this case so far, right?
Yes.
So there's been no other testimony that any other officer made that observation about Mr. Sykes, isn't that correct?
I don't understand your
Now
question.
you're the officer in charge of the case?
Yes.
No, I withdraw that question. I think it's
Okay.
unnecessary. No further questions.
All right, thank you. Okay. Any further questions, any follow-up, or any redirect, sorry?
Detective Files, you indicated that the pills that were located on the co-defendant were taken to MSP, correct?
Correct.
Now, those were also tested, correct?
They were.
And what were the indicative, or what were the results of that?
So MSP reported back to us that the pills were marked as oxycodone, which is consistent with the drugs.com analysis, which again leads it to a reliable resource that we use regularly. Additionally, they did a chemical test analyzation, and based on that analyzation, per the report, the white pills were identified as Alperzam, that's how you pronounce it. It's basically Xanax, and then that's the generic name. And then the other one, again, the ones that were found with Mr. Sykes, consistent in marking and shape and color, those pills were marked as oxycodone but tested as fentanyl.
Objection again, Your Honor, as to characterization of evidence. He's referencing those pills, and I think it's pretty clear that it was only a single
The court
pill.
will take judicial notice that it's one pill.
Thank you,
Yes.
Your Honor.
Judge, no further questions for this witness.
Briefly to follow up, very briefly. In terms of the pills that were found on the co-defendant, those were found directly on his person, correct?
The large batch?
Yes.
Yes,
Removed from him individually,
correct.
not from Mr. Sykes.
No, but as I testified before, that single pill that was found on Mr. Sykes is equivalent to pills that were found on Mr. Timko.
So the only evidence against Mr. Sykes is the single pill that wasn't tested.
Correct.
Thank you, nothing further.
Your Honor, no further questions for this
Okay,
witness.
all right, thank you very much. You step down.
Judge, the people rest.
Okay,
No witnesses on behalf of the defense, Your Honor.
okay. Mr. Chandra?
Judge, the people move to amend count one to possession of fentanyl, Judge, and we reserve right from it for a vote.
I would, well, one, I would object to any bind over on the felony count for controlled substance delivery manufacturer, of course. And then I'll also object to amending this information for possession of controlled substance, because one pill was never tested. They went to drugs.com to try to get a determination about its identity, but never sent it to the lab. And that is the only evidence they have against Mr. Sykes. And Officer Schramm didn't say that he personally spoke with Mr. Sykes and got this blurred and slurred speech. Detective Lyles was not at the scene. He didn't personally speak with them. There's really no evidence. It's also indicate that the car was legally parked. There's really no violation. And I don't believe that sleeping in the vehicle is a violation of an ordinance. If it is, then it hasn't been charged in this case. And just because he was sleeping in a vehicle and a single unidentified or identified by drugs.com untested pill was found, is not indicative of possession of narcotics at all, or use, or whatever the prosecution trying to amend the charge would be.
Okay, thank you.
Judge, with respect to defense counsel's argument, I think it's an understatement to indicate that that the defendant in this case was just sleeping. I think the officer testified that when he made contact with these individuals, they were both slumped over. He indicated when he knocked on the door, the defendant in this case, who was the passenger of the vehicle, woke up. He had slurred speech, Judge. He actually indicated to the officer that he was in Plymouth and he was really in the city of Riverview. In addition to that, Judge, It's correct. They did take the pills from the defendant that was driving the vehicle. I believe it was about 400 pills. Detective Lyles did testify to the fact that they had the same markings, they were in the same car. There was also drug paraphernalia that was located inside of the vehicle. Now, they took those pills, Judge, they had the same markings and they found the same indications of Xanax, and they took those to the labs and they tested them, Judge. They came back as fentanyl. Now, we know, as it pertains to the possession to which the prosecution wants to amend, those narcotics specifically were located under the seat, Judge. So we've established the actual possession. He had dominion and control over that pill, Judge, because they were located underneath his seat. Now, Judge, I believe that we have met the burden of probable cause in the move for Rondo. As it pertains to the MSP lab report, it's already been introduced into evidence. Judge, there was no voir dire as it pertains to the test results or anything of that sort, Judge. So I believe we've met our burden at this point.
Okay, I will clarify. I think that my notes show that I just want to double check that the blue pill and the residue in the rolled up dollar bills and the debit card, those were underneath Mr. Sykes, on top of the seat, not under the seat.
No, Judge, I can clarify, Judge. The officer that testified, Officer Schramm, indicated that there was drug paraphernalia throughout the vehicle. He indicated that there were shards of what he believed was crushed pills.
Right, I know, I heard that testimony. I'm just trying to clarify whether the pill, because Counsel, you argued that it was under the seat of Mr. Sykes. So I want to confirm what I thought I heard was
That was the argument of the prosecutor,
it was under the seat.
not consistent with the evidence of the case, however.
Okay, so the testimony was not that it was under the seat, but it was on the seat under your client.
Correct.
Okay, that's what I wanted to confirm. Okay.
And if I can further clarify, there was no indication as to the location of this other paraphernalia and any connection with that to Mr. Sykes.
Well,
Those dots were never connected.
Right, Judge, but I think a reasonable person can put together the fact that not only of the condition of the defendant in this case, the fact that he slumped over the vehicle, there's narcotics paraphernalia inside of the vehicle, is crushed substance that is indicative of the crushed pills and the pill underneath it, Judge. And they also indicated that there was that rolled dollar of bills, Judge, which would lead a reasonable person to believe that they're snorting this substance.
Wait a minute, Your Honor.
Just one moment. All I wanted clarification on was where the items were located, because my notes showed it was underneath the defendant, on top of the seat, underneath the defendant, not under the seat. So I wanted to make sure that's what I was just trying to clarify. Not inviting any other arguments for anything. And it seems as though it was confirmed with what I thought I heard. So
I would say, Your Honor, that is incorrect, inconsistent with what's in the police report, and inconsistent with what was testified to. That there's no indication that anything was found under the pad.
I understand. That's why. So
no
let me.
indication anything was found.
I understand. I only want to clip.
I'm not making a representation that any of the drug paraphernalia was found underneath the seat. That's not what the officer testified. He indicated that the drug paraphernalia, the dollar bills were located, the rolled up dollars were located inside of the vehicle.
Okay.
I didn't hear anything about rolled up dollar bills.
No, there were two rolled up dollar bills with that residue and debit card with residue. I wrote it as he was talking. So I didn't hear anything about underneath the passenger seat. That's why I asked the question regarding the seat. It wasn't to invite argument about anything else. I just wanted to clarify that because I was taking notes that there was testimony. Okay. And I'm sorry, anything else, Mr. Shahjahan?
Yes, Judge. In addition to that, Judge, defense counsel also indicated that these individuals were legally parked at the time. Judge, the officers were dispatched to this location. They observed this vehicle with two individuals slumped over the seat. It's a welfare check at the very least. What are they supposed to walk away at that point? They made contact with the driver of the vehicle. They had the opportunity and were able to wake both of the defendants up at that time. And that's when they were asked out of the vehicle and then the search begins of that vehicle.
Okay, thank you. All right. The court has heard testimony from Officer Schramm as well as Detective Lyles. The testimony from Officer Schramm was that the officer, that they were dispatched, or specifically he was dispatched to the location on Ray Street, and 2 other officers were also dispatched at the same time. That both the driver and the passenger, and Mr. Sykes was identified as the passenger, were both slumped over / sleeping. There was testimony that there were a few taps on the window, at which point Mr. Sykes woke up, was disoriented, slurring his words. He did roll down the window upon request, told he didn't even know where he was located. He told officers he was in Plymouth. That court will note that that's at least 35 minutes away from Riverview. The court will also note that when Officer Schramm had Mr. Sykes step out of the vehicle, that upon his stepping out of the vehicle, the officer observed 1 blue pill on the passenger seat, as well as residue on the passenger seat, 2 rolled up dollar bills with residue, and debit card with residue. Those are identified on drugs.com, which the court does find is a reputable investigative tool, and is oxycodone. There's additional pills recovered from the driver of the vehicle. Those pills were consistent based upon the testimony with the 1 pill that was found on Mr. Sykes. Detective Lyles also testified that the Michigan State Police Lab, where he took the bundle of pills that were, or the batch of pills, that was the testimony, the batch of pills to Michigan State Police, that they only test a certain number of pills based upon their backlog and their volume. And those pills, based upon the stipulated exhibit number 1, were tested positive for fentanyl. There was testimony that they appeared to be all marked as oxycodone. As tested, they were tested as fentanyl. There was questions by Mr. Mons as to whether or not oxycodone is legal or is permissible, and upon testimony from Detective Lyles with a prescription. There wasn't any evidence offered that there was a valid prescription, but in any event, those pills tested as fentanyl. The court does find that the reason for the officers to be there, at the very least, would be for a welfare check. There was a call into dispatch, whatever that call may have been, that prompted the officers to be dispatched to, or at least the 1 officer to be dispatched to the location. At the very least, the court would agree that would be a welfare check when they observed the individual slumped over in the vehicle. Therefore, the court does grant the people's motion to amend count 1 to be possession of fentanyl, and the court does find that an offense not cognizable by the district court. The probable cause of this belief that both an offense not cognizable by the district court is by committing the defendant committed the offense. I'm sorry, yes, Mr. Shajra?
I have the MCL for the possession. It's 333.7403.
7403? Okay.
My understanding correctly, Your Honor, that therefore, that is the only charge that Mr. Sykes is being bound over on.
Yeah, count 1, Judge, says the only charge is being amended to possession of controlled substance fentanyl.
Yes, there was not a motion to add a count. It was a motion to amend count 1.
Okay, and that motion is granted and is amended to 333.7403.
Correct.
All right, thank you.
Correct. All right, anything else for the people?
Nothing for the people, just thank you.
All right, and sir, you are to appear in circuit court on June 6th at 9 a.m. And sir, if you were to test today, what's in your system?
Marijuana.
Do you have a valid prescription for marijuana?
No, ma'am.
Do you recall when this court, when's the last time you used marijuana, sir?
I want to say 2 weeks ago.
Recall when this court arraigned you, sir, that you were ordered not to possess or consume any alcohol or drugs that are not prescribed?
Yes.
Okay. And so
Your Honor, if I may, you're more than 21 now, correct, sir?
Yes.
And with all due respect, marijuana is now legal and is being declassified. And I think other courts have recognized that since recreational use of marijuana is legal in the state of Michigan, it is less appropriate to have it as a condition of bond. Today, 5 years ago, 10 years ago, absolutely. But today, less appropriate and should not be a basis of revocation of bond. If the judge, please, maybe additional admonishment would be sufficient in this case.
Okay, let me clarify, counsel. This is a possession charge. So this court has ordered your client not to possess or consume any alcohol or drugs that are not prescribed. So marijuana may be recreational, so is alcohol. Your client's not permitted to use any substances that are not prescribed while he's on bond based upon his charge. Now, what other courts permit, not permit based upon their charges, that's not for this court to determine. Perhaps somebody, using marijuana when, it's a disorderly conduct, didn't involve any substances, perhaps that may be what another court is utilizing. In this court, in this case, your client has a possession charge. This court ordered as a condition of bond not to possess or consume any alcohol or drugs that are not prescribed for the safety of the public and the safety of your client. So, sir, you do not have the right while you are on bond to use any substances, legal or otherwise, unless there's a valid prescription.
Yes, ma'am.
Whether it's alcohol, marijuana, which are both legal, right, since you're over the age of 21, the legality of that is irrelevant because you cannot use any of those substances while you are on bond based upon your charge. Are we clear on that?
Yes, ma'am.
The court's not going to revoke bond, but counsel, if there's another violation, bond will be revoked. You don't want to be sitting in the Wayne County Jail, do you, sir?
No.
I suggest you follow this court's order.
Thank you, Your Honor.
Bond and conditions are continued.
Thank you.
Off the record. On the record, in the matter of the state of Michigan versus Leonard, 24638. And detective, your name for the record, please.
Detective Matthew Wiles, MATTHEWLYLES.
All right, thank you, and please raise your right hand. Do you solemnly swear from the testimony about to give this matter the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. You may proceed on the warrant.
Oh, Your Honor, case number 244895. The defendant is Leonard, and the complainant is Tyrese Reeves. This case stems from an incident that occurred on 5/20 of 2024 at approximately 12:11 hours. Before I begin with the incident that occurred at 12:11 hours, I would like to address that there was a previous call for service for a domestic violence incident, which this is a domestic violence case. When the officers arrived, there was a verbal argument between both the defendant and the complainant in this case. They were cooperative, and the complainant stated he would leave the apartment to calm down. However, he did not because the defendant disconnected his phone, and he felt that if he had left, he wouldn't be able to contact anybody. So he decided to stay at the residence after the officers had left. At 12:11 hours, officers were dispatched to 151 City of Riverview, which they were previously at as well, for another domestic incident between these same two, complainant and defendant. When the officers arrived, they spoke with both parties. The complainant stated that there was a verbal argument that had escalated, and that the defendant had threw a chunk of asphalt or a brick-shaped concrete object at him. officers did observe that there was a brick-like concrete object that was laying where the complainant had pointed to it had landed when it was thrown at him. Officers did photograph that as well. When officers spoke to the defendant, she stated that it was only a verbal argument and that she did not throw a brick at him. She was subsequently placed under arrest based on the information provided by the complainant and based on the previous call for service and all the other totality of the circumstances involved in this case. The officers, and also with the back to where the brick was laying and how the complainant had described it, and along with the fact that the brick appeared in other buildings to be a door stopper. So that's not where it was supposed to be based on the totality of it. While Miss Leonard was being processed, she made an unprovoked statement, an excited utterance to Officer Harper and stated that the complainant had come after her with a pocket knife, and that is why she threw the brick at him, even though her original statement had contradicted that. And she said it was only a verbal argument. She did not throw the brick. And that is all I have for you, Your Honor.
All right, thank you. Upon examination of the complaining witness, I find the offenses charged were committed. There's probable cause to defend commit those offenses. Right, we'll just wait for, we'll go off the record. We'll wait for her to, all right, and so we will go on the record in the matter of the state of Michigan versus Lamaya Leonard, 24638. And counsel, your appearance for the record, please.
Yes, good morning, Your Honor. Neil LeBlanc here on behalf of Lamaya Leonard.
All right, thank you. Ms. Leonard, your name for the record, please.
Lamaya Leonard.
All right, and please, counsel, as to the arraignment, what you're to do.
Yes, my client's waiving formal reading would stand the charges.
All right, the court will waive the formal reading. Ms. Leonard, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today. Is that correct?
Yes.
All right. The court has also signed a petition in order for court appointed attorney for felony matters. And the court will note that you also have the right to be presumed innocent to proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
All right, the court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on May 30th. What time works for us, Alan? At 9:30 a.m. And counsel as to bond.
Yes, as the bond, Ms. Leonard advises that she's never failed to appear for any court hearing. She has no prior convictions. She is gainfully employed with the program since last year. We ask the court to take those into consideration and grant her a nominal bond.
Where's the court? Yeah.
In Romulus.
How long have you worked there?
Since October 8th, 2023.
And you reside at the apartment? Whose name is the lease in?
Mine. I'm the primary resident.
Okay, ma'am. How long have you been working at the district?
Since October 8th, 2023.
And you just filled out this request an appointment for attorney, correct?
Yes.
Okay. So
Sorry.
why did you write unemployed on here?
Because I don't know if I still have my job after coming into here. Because they will fire me if I don't show up. They have a point system.
Okay. Did you have anybody contact your employment man while you've been in custody?
I asked her, she said I had to wait until I seen a detective in order for me to contact anybody.
Have you ever failed to appear in court before?
No.
Are you on probation or parole anywhere?
No.
Counsel, can you speak to the charge from June of 2023 that shows it was released, no prosecution?
That is the homicide.
Yes.
She advised me that there was an investigation and
Okay.
she was free. There was no charge.
Okay, Detective, your name for the record, please.
Detective Matthew Lyles, MATTHEWLYLES, badge number 62.
All right, thank you. And as to bond.
Yes, Your Honor, just to add a little bit to the homicide charge. I did speak with Ms. Leonard in regards to that. She, obviously I can't fully confirm her story, but based on her cooperation, I do believe that she's being truthful. She stated that she had hit a small child with her vehicle and was arrested, but not charged by the Wayne County Prosecutor's Office due to the fact that it was an accident. However, because the child died, she was charged, or I'm sorry, she was arrested for homicide.
Okay,
But to my knowledge, it was not an assault or anything of that nature.
okay.
Again, Ms. Leonard has been cooperative with us. She does not have a criminal history other than the arrest by Detroit Police Department in June. She does not have any outstanding warrants. She has not been a flight risk. I do believe a 10% bond would be sufficient in this case. It is a felony case, an assaulted felony case. However, it is domestic in nature. It's not a stranger. I don't believe that there's necessarily any danger to the public. However, there is a concern that there would be danger to the victim in this case, and they do live together. She has conveyed to me that she can live with her mother in Lincoln Park on Hanover Street. So I believe a GPS tether would be suitable for this situation, just to prevent her from going over there, because it sounds like the only time she has an issue as far as legality or legal issues go is when she's with him, because we do have previous calls there. Sufficient, Your Honor.
Okay, and Detective, do you know how long has Mr. Tyrese been residing at the apartment the same time that Ms. Leonard has been?
Yes, my understanding is that they've moved in together and they've both only been there a few months.
Okay. Is that accurate, ma'am?
Yes.
Okay. So here's what the court's going to order. Based upon the nature of the charges, the previous contacts with the police regarding these two individuals for the same type of issues, and to ensure the safety of Mr. Tyrese and to ensure Ms. Leonard is going to be appearing in court, the court does find that a $10,000 10% bond is appropriate. These are the following bond conditions. You're not to have any contact with Mr. Tyrese. Let me clarify, Mr. Tyrese Jr. That's phone contact, text message, email, social media, third party, anything of the like. Now, social media means contacting him directly, indirectly, posts about him, anything of the like. Is that understood, ma'am?
Yes.
You're also not to return to the apartment on Brookview Drive, with the exception to obtain personal belongings that are necessary for your day-to-day living, as long as you are accompanied by a police officer. So what that means is that you will contact the police officer first, then they will give you directions as to how you are going to proceed, whether you're going to the police station and drive all together or follow each other, or you meet somewhere, what have you, but you don't go to the property and then call the police. You contact the police first, okay?
Okay.
You are not to possess or consume any alcohol or drugs that are not prescribed. And you also are not to possess or have access to any firearms and or any weapons. Do you have any of those at your home, ma'am?
No.
You also already have a GPS tether, no house arrest. And the court's going to note that will be through the Wayne County Jail. Any questions regarding the bond conditions?
No.
No.
Okay. All right. You'll get a copy of your bond conditions, and then we'll see you back on May 30th. Thank you.
Thank you, Your Honor.
Thank you. All right, off the record. And so we're on the record in the matter of the City of Wyandotte versus Michael Foster, 24653. And counsel?
Good afternoon, Your Honor. Neil DeBlois here on behalf of Michael Foster. Mr. Foster, can you state your name, please?
Michael Foster.
All right, and so counsel as to the arraignment.
As the arraignment, my client waives the formal reading of the complaint, stands mute to the charge.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. We'll schedule this matter for a pretrial on June 5th. And as to bond counsel.
As to bond, first some housekeeping matters. His address and telephone need to be updated. He advises me that his current address is Detroit 4202.
Okay.
In addition, his correct telephone number is 810.
Okay. All right, and so,
With respect to the bond, Your Honor,
yes.
I'd like to address the allegation in the complaint. The allegation is that he was in possession of one or more Adderall pills. Mr. Foster, if true, Mr. Foster advises he has a valid prescription. He is diagnosed with ADHD, bipolar. And again, as it relates to the bond, we have he is in therapy and treatment under doctor's care. His personal situation is that he does have employment at a company called Williamson's Holdings, I believe. He hasn't worked there in the last couple of weeks. He said he's been in the process of moving, hence the update on his address. As I say, he does have some medical issues which are in treatment, and the medications he had with him that day, he assures me that he has a valid prescription for. So taking all those things into consideration, maybe giving him the benefit of the doubt, we ask for a personal bond.
All right, sir, who do you live with in the home, sir?
I live by myself.
Okay. Yeah,
Right
there's a
now.
couple warrants. There's a couple warrants, sir, that you failed to appear for in Livonia.
In Livonia. I don't have anything
I'll
around.
check and see who those are for. Just one moment.
The person that I was in the car with last night had warrants already.
Oh, those are for Nina. Have you ever failed to appear in court before, sir?
No,
Are you on probation or parole anywhere?
no,
Are you out on bond in any other jurisdiction?
no.
What happened on your felony assault matter out of Flat Rock in December from New Year's Eve?
They had dropped that charge. They didn't go through with it. I was in there I was in the police station for 2 days, waiting to see the judge. Then the police officer came back and said that the district attorney didn't take charge, so I got released.
Well, here's what the court's going to do, sir. What's the name of the place that you work, sir?
It's a family company, and we work on mobile homes.
Okay. How long have you worked there, sir?
I've been working there for 8 months. The last 3 weeks I have not been going due to I had moved. So I've been working on fixing up my house that I'm at right now. There's been problems with the plumbing, the roof, and then the heating. So I've been fixing all that up and while moving. And as soon as I'm done fixing up my house and everything, I can go right back to work.
Okay, here's what I'm going to do. Given the nature of the charges, the court's going to order a low cash bond counsel of $2,500, 10%. In the event you post bonds, you're not to possess or consume any alcohol or drugs that are not prescribed to be subjected to random testing. Actually, I'm going to not order the random testing.
There's no other way that I can release, because I do have proof that my medications, I have scripts and everything all at home. I'd be able to bring them up right back as soon as I get released too, to show and prove and everything. I even have my phone that has my.
So can you come up with $150?
Today I can, not today, right being in here, I cannot. I had to be out in order to be able to do that. I only have $5 on me right now. And I literally was supposed to go back to work today, but I got locked up last night, and I told my attorney that too. Like, I know I did mess up and just have like one or two of my eyeballs on me at a time, but I didn't want to bring my whole script with me. And I knew I wasn't going to be home during 7 o'clock in the morning.
I don't really want to get too far into, hold on, sir, I don't really want to get too far into the facts of the case. I do have some concerns. I can bring it down to 1,500, 10%.
How much would that be?
That's $150, sir. You can just make some phone calls.
All right, well, I'll keep on.
All right, I reduced it to 1,500, 10%. That's the best I can do. You have the nature of the charges, sir.
All right, well, be able to make some phone calls.
Okay. All right, thank you. We'll see you back in 2 weeks. Have a good day.
Thank you.
Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am, can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm going to be, I'm the one that needs a drink.